5 seconds to go. Start. The respondent having retired after working for about 26 years, the petitioner state cannot raise the question of proof of prior permission before resignation, more so when the appointment had been made through the RPSC to a government post. Stop. It is to be deemed that there has been disclosure of past service and the application has been made through proper channel by obtaining the requisite approvals. Stop. Para. It is to be presumed that prior permission had been taken unless the contrary could be established by the state. Stop. Maybe there was a delay of 6 years in filing the writ petition, however, it is well settled that the laws of limitation do not apply to exercise of jurisdiction under Article 226 of the Constitution of India. Stop. Relief under Article 226 of the Constitution of India being discretionary, the courts might in their discretion refuse to entertain the writ petition, where there is gross delay on the part of the writ petitioner, particularly, where the relief sought would, if granted, unsettle things, which are already settled. Stop. Para. In this case, the respondent writ petitioner is claiming pension, which is a lifelong benefit. Stop. Denial of pension is a continuing wrong. Stop. This court cannot also be oblivious to the difficulties of a retired employee in approaching the court, which could include financial constraints. Stop. Para. It is settled law that when financial rules framed by the government, such as pension rules, are capable of more interpretations than one, the courts should lean towards that interpretation which goes in favor of the employee. Stop. Para. Miss Archana Pathak Dave, counsel appearing on behalf of the respondent argued that Article 136 of the Constitution of India does not create a regular forum of appeal. Stop. It is only a residual provision which enables this court to interfere with the judgment and order of any court or tribunal in India, in its discretion, as observed by this court. Stop. Para. Citing Bengal Chemical and Pharmaceutical Works Limited versus Employees, Ms. Dave argued that since power under Article 136 of the Constitution of India was discretionary, this court is not bound to set aside an order under Article 136, even if it was not in conformity with law. Stop. Para. The High Court has rendered a just decision based on a purposive interpretation of Rule 25(2) of the rules applied to the admitted facts on record. Stop. The interpretation given by the High Court to Rule 25(2) of the rules is a plausible interpretation. Stop. Para. We, therefore, find no grounds to interfere with the impugned judgment and order passed by the High Court. Stop. Para. The special leave petition is, accordingly, dismissed. Stop. Para. This special leave petition has been filed challenging the final judgment and order dated 28th November 2019, in DB Special Appeal Writ number 443 of 2018, passed by the High Court of Judicature for Rajasthan Bench at Jaipur, whereby the High Court dismissed the writ appeal filed by the petitioners and upheld the judgment of the single bench dated 5th May 2017 in SB Civil Writ Petition number 5879 of 2009, whereby the single judge had allowed the writ petition filed by the respondent. Stop.